It was anticipated, and finally the Supreme Court delivered that much anticipated verdict. And if you're wondering what happened today, well, I'm going to walk you through what happened today. You know, the Parliament has been one center of major controversy. Many have said it had triggered a constitutional crisis, and indeed it is one. It pitched the Speaker of Parliament, Parliament itself, against the judiciary. And many who have watched this space for decades say they have not seen this level of controversy, this level of gridlock, this level of bickering between those two major organs of government come head to head and clash like we've seen the legislature clash with the judiciary over the last 3 weeks or so. Because of this controversy, as you know, Parliament is in sitting. It has been adjourned indefinitely, and the Supreme Court was in haste to try and bring closure to this. The Chief Justice herself is on record to have complained about Parliament not sitting. And many have criticized her for even making that comment and pronouncing a constitutional crisis. So today, big day indeed. And many expected that this outcome would have ended the controversy around who is majority and who is minority. It all had to do with 4 seats that the Speaker of Parliament declared vacant. So what happened today? If you missed it, 5-2. That was a decision in Parliament, in the Supreme Court, and not Parliament, of course. Why would I not say Parliament? Because that has been the narrative over the last 3 weeks. Parliament is taking the decision. Supreme Court is either staying that decision or, in this case, overturning that decision. And so it's been a tango. But today, the Supreme Court delivered its verdict. 5 saying, well, the Speaker of Parliament acted unconstitutionally when he declared those 4 seats vacant. 2 of them disagreeing with a particular position as expressed by those 5 judges, saying, well, the Chief Justice and the lot who agreed with her were wrong, and that the Speaker was right to do so. And so Afenyo Marking is the one who had gone to court. He is the majority leader, and that matter is settled tonight. And he has been out there chasing anyone who did not call him a majority leader. Even those who said is a leader of the MPP caucus. And in fact, he is the leader of the MPP caucus in Curtis Rough. That matter, he can sleep a bit more soundly tonight, knowing that the Supreme Court had delivered a judgment that should settle this matter about who is the majority, who is the minority. So this is the decision of the Supreme Court. We don't have the detailed reason judgment yet. What we do know is that Afenyo Marking won at the Supreme Court, and so he expects that his side is the majority, and they will go to the House the next time it is recalled. So who are the judges? And we must know, who are the judges who voted in favor of Afenyo Marking's position, and who were the judges who voted against him? 5 of them, including the Chief Justice herself, Enes Gaiwu, a very controversial one indeed. I'll come to that pretty shortly. You also have Samuel Asidu and Mariam Awusu and Yawasari Dako. 5 of them said they agree with Afenyo Marking's position that the interpretation of that particular constitutional provision by the Speaker was unconstitutional, and as such, that act cannot stand, and it's settled now. But 2 of the justices dissented, and they were clear. Lovelace Johnson, Amadou Tanko were clear that the position taken by the 5, wrong. The Speaker was right to interpret so. I mean, and we will get into the specifics pretty shortly when my guests join me. But I want to raise the subject of Enes Gaiwu. You know, he was at the heart of this. At one point, the Speaker's lawyers had raised a concern, and I asked that he recuse himself from the panel. He didn't, because the judges considered it and overruled, of course, throughout the particular application for him to recuse himself. Why was that the case? We know he used to be a former parliamentary candidate of the MPP, and that is one of those issues that had made this very controversial judgment even more controversial, now that it has been pronounced. And you cannot take this out of the context of the elections, which is just over 20 days away, right? All this is happening within that context. And so it really makes this a very interesting outcome indeed, and we'll see. The ball is back in the court of Parliament and the Speaker and what the Speaker will do. A few things we need to do. Let's understand how quickly this has traveled. And this all started on the 15th of October. What happened there? Haruna Idrisu had just hinted and petitioned following that some 4 members of Parliament were actually in breach of that constitutional provision because technically they had crossed carpet. One of them had gone independent. One of them had actually joined the MPP when he had gone into Parliament in 2020 as an independent candidate. I'm talking about the second Deputy Speaker of Parliament. And 2 of the MPP, on the MPP side, we know they're gone independent, although they're in this current Parliament as MPP parliamentary candidates representing their constituency. And then there's one from the NDC side also in that same particular bracket. He raised that, petitioned the Speaker. Now, even before the Speaker could deliver his ruling on the subject, Alessio Nyafanyo Marking went to the Supreme Court. He was seeking interpretation on that particular subject as it relates to the Constitution, Article 97 G and H. And so he asked the court. And then many said, but why are you going to court when the Speaker had not pronounced on the matter yet? But you have to pay attention to his strategy. His strategy was he anticipated that the Speaker would do this on the 17th of October, which fundamentally was to say, well, the petition before me is valid and those seats are vacant. And so he went to court to preempt it, right? To preempt it. But his strategy was to say, this is a subject begging for constitutional interpretation. He had no bearing on what might be 2 days later, but I'm asking the Supreme Court to interpret. Whatever the outcome here, this will affect it. That was his strategy fundamentally, which is what he did. And again, when the judgment, the decision by the Speaker came, he had agreed that those seats must be declared vacant. And then quickly on the 18th, the day after that, the Supreme Court halts the Speaker's decision. So this is very, very quickly traveling at the speed of light. Knowing our courts very slow, this traveled at the speed of light in 24 hours from the 15th to the 18th. Great strategy there by Nyafanyo Marking. He's won that. And then we talk about the 24th. MPP then recalls Parliament because they got the signatures, triggered a constitutional provision that allows that to happen. And then we know on the 7th of November, they skip Parliament. The Speaker then adjourns indefinitely. And so then you begin to see this has real fundamental implications for all of us because Parliament isn't sitting. Government business is not happening. MPs are campaigning. The life of this Parliament is running out and will evaporate very soon, but they can't do any business because of this particular issue. And so the Supreme Court decided today, let's be expeditious about it and put this to bed. And so they decided that they are going to deliver a judgment, which is really the judgment that they delivered today to say, in essence, that the Speaker was wrong. His decision was unconstitutional. But something else that you may have missed in all this, if you have not followed, right, is that the Speaker, although started by being very vocal in the Supreme Court, making a case why Nyafanyo was wrong, did not show when the case was last called. He wasn't in court. And in fact, he did not even file his case when the Supreme Court asked him to. So it was a complete no-show. The Supreme Court's decision was arrived at and delivered without the Speaker's side had written and considered because it wasn't there. It was a complete no-show. We still don't know why. Was he sending a message to the Supreme Court, in essence saying, maybe the outcome, he thought, maybe premeditated, because he's complained about this already. Maybe, is that why? But also, you remember that the Attorney General has raised the subject before the Supreme Court that his lawyer had been illegally procured because the procurement authority had rejected it and they had not gone to due process, right? And that the Attorney General had also argued that he, the Speaker, should not even be part of this particular trial because it is him, the AG, who should be leading this matter as the representative of the state, right, in court. And so, but he didn't show. We will still waiting to see why he didn't show. The Supreme Court, in essence, said today, whether you show or not, we can go ahead. And they did go ahead without a side there. So the big question, and this is where the controversy is, what does this do to this confusion over who is majority and who is minority? As far as the law is concerned, as far as the constitutional architecture is concerned, on the back of the Supreme Court ruling, this returns, the MPP is the majority, the NDC goes to the minority. And you'd expect that the seating arrangement should change. But, wait a minute, not that fast, because some members on the NDC side are already telling us, well, they will still sit in that position. And the minority side, we haven't given the leadership yet, but some of their key members are saying they will sit there. It is up to the Speaker of Parliament himself, and we've heard from Avonya Martin today say he expects a Speaker to make a directive on the matter when they last sit. And I want to bring this up because the judiciary is in place in this very difficult position, if you like, trying to answer the political question when it comes to Parliament. And then a lot of the courts have shied away from this. The jurisprudence is there 3 decades. They don't want to enter that fray and answer the political question. But they've been invited to do so. And it's all happening within the context of a very credible service coming up that actually paints the judiciary in a very, very bad light. Considering where we're coming from in 2014, when you look at the Mo Ibrahim index when it comes to Ghana's judicial autonomy, we were at 100%. We're doing great. And then we fell to 50%, half of that in 2018 there. And we've kept that plateau over the period to 2023. And that is definitely a picture that a judiciary will be very worried about, because that is a significant drop and it hasn't changed. But this, for me, tells a story of what people make of the judiciary in these times. We were first on the continent when it comes to impartiality of Ghana judicial system. Then we dropped to 4th in 2016. We gained one position in terms of the rank back to 3rd in 2017. Great. And then sharpest drop yet in 2023 to 12. So something really fundamentally is happening here that isn't good. And then you talk about the Afrobarometer. This is back-to-back, very credible survey saying we've dropped. 65% of respondents for Afrobarometer say they've lost trust in Ghana's courts. 22% drop in there. And then previous holders of the Chief Justice's position have also been critical. You have Justice Ofer Akufu rendering some scathing critique of the current judiciary and its decisions. You have Justice Otuguba making the same case today exclusively to us on the back of the judgment, saying the Supreme Court should not even have entertained this particular matter. It should have gone to the High Court before getting to the Supreme Court. And then you have Joseph Withal delivering a very withering, no pun intended on the name Withal there, criticism and scathing indeed of the Supreme Court yesterday and the judiciary generally about us not burying our heads in the sand, because he says the Afrobarometer report and the Mo Ibrahim report is a reflection of reality. And then we've also seen today, in the last few days, Chachi Chikota also criticizing the judiciary. So what really is happening there? And that's today's verdict. Confirm their position or validate what they've been saying, or really, the Supreme Court is simply doing its job and looking strictly at the law and making those judgments. We're going to be talking to my guest who will join me pretty shortly. Stay with me, because this has implications. I'm interested to know what should be the direct implication of the judgment. Does that settle the confusion in Parliament? And should Parliament be recalled as soon as possible so government business can be done? Here on PM Express after this. PMS is always brought to you by Syntex Tanks. It is strong, it is tough. Academic Times, Pepsodent Cavity Fighter Toothpaste. Academic Times is an incoming graphic and online publication aiming to collaborate with university authorities and students to ensure that students' research is published in summary form. Syntex Tanks, Ghana, get ready. The biggest giveaway from Syntex Tanks. Syntex is visiting 15 communities, giving them free water. This is to say thank you for your making us the #1. And now if you are a community and you want to benefit from Syntex free water giveaway, just log onto social media handles at Syntex Ghana and nominate your community. Syntex Tanks are strong, are tough. And Pepsodent Cavity Fighter is the one to recommend every time we eat. As you know, food and sugars are trapped between our teeth, leading to tooth decay, gum disease, and in some cases, foul breath. That's why you need to find a Pepsodent cavity fighter and use it, because it will improve significantly a feeling of your breath. By the way, I want to bring in my guests who are joining me for a conversation right now. Frank Davis is joining me for a conversation tonight, and you know him. He is the chairman of the Constitutional and Legal Committee of the MPP. We're also joined by Mr. Kpebu, Martin Kpebu, who is a private legal practitioner, and we're joined by Godwin Eduju-Tamaklo, who is the Director Legal Directorate of the NDC. Mr. Davis, this outcome that we saw today, was it expected, anticipated, as many people had said?
Good evening to your cherished viewers and listeners. I don't get what you mean by anticipated outcome. A decision or a judgment in every matter rose out of submissions that are made in court and the statement of case before the justices. So I don't understand why you should mix up your statement by it was anticipated. I mean,
no, it was deliberately so, because you have the speaker, who is the only party in the matter who held a different view to it, not filing a case. So the Supreme Court only had one side of the matter. Obviously, you can expect an outcome. That's why I pitched it like that.
But Evans, I mean, was the speaker not given an opportunity through his lawyers to also put up his case?
He was.
Yeah. So then, if he elected not to do so, why would you say it was anticipated?
Yeah, but he elected not to do so.
But what? In any event, there's a matter before the court. You have been cited as a defendant. You attempted to vacate the orders of the court. The court did not agree with you. Your lawyers were in court. They were given the opportunity to present their statement of case before the court. They didn't do that. You think what the judges should have waited for the speaker ad infinitum? And then when a judgment of the court is rendered, you say it's anticipated. How can that be anticipated?
I mean, but I'm not. At least, I don't know why you take. You don't take that negatively. What I'm saying is, on the face of it, if you have two sides to an issue, and one side is not represented in the matter, whether they chose or didn't choose, you can expect then that the judges will have one view, and the judges depend on the arguments that are made before them to come to the conclusion. Of course, they'll add their own insights. I'm just reading to that and say, if I'm sitting back and watching...
Yeah, but the judges, but that is what I'm saying is wrong. To say that it was anticipated is wrong. The judges don't have it. That is why you have two judges dissenting.
Yeah.
That is why you had two judges on the panel dissenting, even though there was no statement of case from the first defendant.
That's
so it cannot be anticipated.
No, but
it's a judgment of the court. So don't say it's anticipated.
Where I said it was
because
anticipated.
Even, listen to me. Even without them filing a statement of case, the five other justices would have held that the interpretation was in favor of the speaker.
But it didn't.
Well, let us take the judgment
it didn't,
and not talk about anticipated judgments.
No, it didn't. There's a reason why the Supreme Court had asked them to file their case. There's a reason.
Yeah.
There's a reason. Because they wanted to hear all sides, and they didn't hear one side of the matter. It's not their fault. The other side chose not to put their case in. So watching it, I would say, well, of course, I'm expecting an outcome that obviously will represent one side of the case, which actually put their case forward. If I'm a judge, I want to be convinced.
And I'm saying that notwithstanding, Evans, you're not listening to me, that notwithstanding, two of the justices dissented. So what are you going to say about them too?
Yeah, but they dissented.
Two dissented.
But I'm talking
and
about the
five
court.
were in the majority. So
it's a court's decision. It's a court's decision.
I mean, is what?
It is a court's decision.
Decision, yeah.
Yes.
It's a majority decision, 5-2.
Exactly my point. I mean, we shouldn't
quarrel. So you can't say it was anticipated.
We shouldn't quarrel over that. I mean, it's the way you see it is my question to you.
No. Even sometimes, you see, we communicate to a larger medium. Your station, your television station is arguably the most listened to and the most viewed station. I mean,
yes,
take it.
But
when you say these things, it gives a wrong impression.
No, it doesn't. It doesn't.
That's a judgment of the court.
No, there's a context to that question. It's not. It's a question to you. It wasn't said in a vacuum. There are issues surrounding that led to my question to you. But you concede. one side didn't present a case. It is
True
reasonable. It is reasonable. It's reasonable to expect.
True whose fault?
Say that again.
I said true whose fault? One party did not present its case. True whose fault?
No, but I've said it many times that they were given an opportunity to make their case and they didn't.
Yeah, so if they did not present their case,
but without that
the judgment
side
of the court is handed. It's handed.
That's a fine. But without that side, it's reasonable to expect that the outcome obviously will most probably inure to the favor of the guy who actually made a case. That's reasonable.
Well, say it as you want to say it. If you don't want to toe on the line of objectivity, and this is what you are going to say it. I mean, I think I've made my point that phrase you use was unnecessary. That anticipated judgment was unnecessary because two of the justices dissented.
Yeah, but
why are you not laying claim to that?
Two of the judges.
But why are you saying because the 5 were in the majority is anticipated? That's the judgment of the court. Let's leave it as that.
Well, I mean, that is not the substance of the conversation. Let's come to the substance of the conversation. We're waiting for the detailed reason judgment. We don't have it yet. But this matter is now being put to rest. What for you should be the immediate implication of this? Because we know, the reason why this is important is because it affects the conduct of government business in Parliament fundamentally, right? So what should be the immediate implication of this judgment?
The immediate implication is that the Speaker should once and for all obey the judgment of the Supreme Court. This time it's not an order, it's a judgment of the Supreme Court. And you see, before we started the program, you actually showed some persons who have over the years, have for some time now, you claim to be making some pronouncements about the Supreme Court. The Supreme Court not being whatever. But I must say that one of the justices, that is Justice William Atuguba, I just want to believe that the Speaker will for once take inspiration from what Justice Atuguba says, since you hold him in so much of an esteem, that once a judgment or an order emanates from the Supreme Court, no matter who you are, you have to obey that judgment. No matter who you are, even the president cannot afford to disobey the judgment of the Supreme Court because it has consequences. So I want to believe that the Speaker would for once abide good reason and allow the judgment of the Supreme Court to reign. There is only one Supreme Court we have in this country, and that Supreme Court is the master of our Constitution. So when the judgment of the court has been handed, I expect that the Speaker, who is also a trained lawyer with so many years of experience, will just do the honorable and right thing and allow the judgment of the Supreme Court to prevail.
Let me bring in Martin, your other colleague, into the conversation. Martin, did the Speaker shoot himself in the foot by opting not to put in a case when he was given the opportunity to do, and in fact, the court actually gave him time to do so?
Evans, that is not easy to say. It is not easy to say because here the Speaker granted an interview, a press conference, where he said that there was collusion between the executive and the judiciary. So sometimes that is where we are himself in the foot. So we are analyzing his utterances, his statements to see. Somebody who has said so, you should not be surprised that he didn't give instructions for a statement of case to be filed on his behalf. And don't forget, where the Speaker sits, he's privy to more information than you and I. And don't forget, this is a judiciary that even the Chief Justice herself admits that it's not independent enough. So at her vetting, she said she's looking forward to a constitutional review where the
Oh, goodness. Let's see if we can get him on a better line. Let's try and get him on a better line. I want to bring in Eduji Tamaklo whilst we try and fix Martin Kpebu's line. Eduji is with me on the phone, by the way. And Eduji, where do you stand on that question, that same question that I asked Martin there? Because as we know, the lawyers of the Speaker didn't put in the case. We don't know why, but they had two judges, as we know, who agreed with them, even without making a case. They agreed with them. It almost suggests to me that if they had pushed their argument harder, they may have flipped a few more judges on their side. Didn't they shoot themselves in the foot?
Okay, so good evening to your viewer. I think the fundamental question is the Supreme Court bound by the written arguments by parties? The court has consistently stated that they are not bound by the written legal arguments of the parties, and that as far as they are concerned, they have the power to interpret the Constitution. The only thing that the submissions by lawyers does is basically to offer some assistance to the courts. Two, the lawyer for the Speaker, my old senior Tadio, sorry, if my memory serves me right, in the last conversation at the court, at the tail end, the Attorney General Godfrey Adame basically sought either to create an impression before the court that Mr. Tadio Sori does not have proper, let me say, authority to represent the Speaker, and that in his view, a request for a sole source approval to the PPA was declined, and sought to question the standing of Mr. Sori to represent the Speaker, and even proceeded to say that in such constitutional matters, he ought to be the one defending the action. So if the Attorney General, by coincidence or whatever, has been given what he wished for, where from the complaint? Why are we complaining?
Overruled him. The Supreme Court overruled him then and actually gave the lawyers of the Speaker an opportunity to do so.
No,
only for them to show not to.
I am saying that having made those pronouncements, and now you have the opportunity, why was the Attorney General now telling the court that the absence of the Speaker's lawyer was disrespect? Why is the Attorney General fond of inciting the court against fellow lawyers? I think that is extremely mischievous and diabolical. We shouldn't encourage it. But that's it. You see, Eva, we find us in a very a situation that we ought to protect. Unfortunately, our friends have even asked what they are hoping to say at night, and have taken a view that the provisions in Article 94 are futuristic. I am and handicapped in the sense that the judgment and the reasoning of the Supreme Court is not out yet. We will definitely have opportunity. But I want to find, and I'm praying, that I'll see an order in the judgments by the majority. Direct Parliament to read. Because I just listened to my learned senior say the issues of government business, among other things, and I'm Mr. Speaker. With the greatest, has the Speaker of Parliament disobeyed any judgment of the Supreme Court or orders? Evans, has Speaker Bappe disobeyed or refused to enforce any judgment or orders of the Supreme Court of Ghana.
But before today, Eduji, before today, there was a stay that the ruling that the Supreme Court delivered stayed his earlier decision in Parliament, which in essence restored the status quo. And yet, when Parliament was recalled, he watched on as the NDC side sat in the majority seat. He shouldn't. He should have. He should have asked them to move away because the court has stayed and what existed before then has existed.
The orders made by the state, was it within the province? Did the Supreme Court list or state who is majority or who is minority?
No, the Supreme Court didn't.
So what is it that the Speaker did wrong when the Supreme Court never says?
Well, there's a lot there. I mean, his ruling was simple. He declared 4 seats. This is simple. It all adds up. He declared 4 seats vacant. The 4 seats that he declared vacant is the reason why the MPP side went into minority and the NDC side became majority, right? And that's what started this. And so if his hand had been stayed, everything else that he did ceases and will return to what it used to be. The status quo is reinstated.
Did the Speaker prevent the 4 MPs from assuming their seats? Did Speaker Bag prevent Andrew Siama from coming to power? Did Speaker prevent Kweju Asante, Cynthia Morrison, Peter Kwachi from taking their seats?
I guess the question to ask really is, at the time that the recall happened and Parliament was in session, was the MPP side the majority or not? And the answer there is... Did the
Supreme Court rule on the question of who is majority or minority?
The Supreme Court stayed the decision that made the MPP the minority.
The Speaker is one, declaring the four or informing Parliament that those seats are vacant. Beyond that, did the Speaker do any other day? Beyond that day when Mr. Speaker said those 4 stands vacant, beyond that statement, has Speaker done any other thing? Did Speaker say today, NDC MP majority? Did Speaker say from today, MPP MPs minority? So please, you see, you people have said a wrong question, and you are helplessly looking for an answer. In any case, where in the stay granted by the Supreme Court did he say that going for the MPP led by African constitute the majority?
But the stay did not have to say that. The stay what was the stay about? What was the Supreme Court staying? The Supreme Court was staying the Speaker's decision to declare seats vacant.
I have a copy of the stay. Nowhere in the stay granted by the Supreme Court did he say that they are either those who were minority to go back.
No,
to
I mean, we all know the state didn't say that, but the implication of that state, well, it's simple. I mean, this is so obvious on the face of it.
You have elevated the conversation now from the orders to intent. Please, you see, the last time during the proceeding, the leadership, the Chief Justice, made a profound statement. He said the country is in crisis, and that Parliament is not sitting. Mr. Sorry retorted, her leadership, is this suit about affecting Parliament to sit it? What was the answer she gave? You see, it appears that the real intention for going to court is to get Parliament to reconvene and not the belief that the plaintiff was seeking. But the question we need to ask ourselves is, with respect, is it within the province of the Supreme Court to order Parliament where it Look, you see, Eva, you have done this work for a while now. Let's get back. Has any MPP beyond the four been prevented from conducting government debt? No. The minority leader whose across per the judgment of the people according to the law walked out of parliament. In the superior minds of the framers of the 19th Constitution, they never envisaged that the president must necessarily have majority in power. They have always looked at the situation where even have a coalition government or a government founded on consensus. If people, ego, pride, are not willing to cooperate with the colleagues to ensure the smooth running of. You can go to the Supreme Court, and that is why I was asking you whether part of the orders made by the Supreme Court includes ordering Parliament to reconvene. The Supreme Court never did that.
Okay, stay with me. Let me get Martin. Let me get Martin to that question. And Martin, you were earlier talking to me about you giving your assessment of whether or not the absence of a statement of case from the Speaker's lawyers may have played a role in the outcome we saw today, and whether they shot themselves in the foot.
Yeah, Evans, I was making the point that what it is that what the Speaker has said is in cahoots with the executive. And so, having said so, it means that he is probably deliberate in not going into the court. That is to say, not making sure that his statement of case is filed, because he knows what he's talking about. Then I join it with the fact that the Chief Justice herself is enough. Very clear, it's incontrovertible on 2 occasions at least. One, at her vetting, when she was asked, in this whole constitution, what does she want changed? The first thing she mentioned was that she doesn't want the president to have a role in the discipline of judges. Obviously, because it enables the president to impact here at the bar conference in Cape Coast. She mentioned that the executive refuses to release money to the judiciary, and that affects the efficiency and effectiveness of the judiciary. So what is that? Control. So when you put this together, you find a statement by the Speaker that there's collusion, there's no independence. You find it justified. So when it comes to separation of powers, it's buy one, get one free. So when you become executive president of Ghana, then in that case, you get to control the judiciary. So straight. The executive is always interfering in the affairs of the judiciary, always trying to influence judges. Listen, we have to pray with all the strength we can muster. It is not new. It didn't start today. It's always been there. So the president's power to appoint judges of the superior court.
But I'm curious, Martin, what has that got to do with today's outcome?
Oh, so we are talking about
goodness.
We find an analysis that the executive is always trying to control the judiciary. If you find thinking that it is the control that is producing that result, very fair assumption. Very fair. I'm not adding anything. We are using the Chief Justice's own complaints and wishes about constitutional change to make their analysis. I've not added anything. I've not added any personal opinions. We are talking about there is not independent enough. Using that to arrive at the conclusion that, then with such a decision, somebody, that is to say, reversing the speaker on the vacation of the 4 seats, somebody can assume that it is the control that has yielded such a result. It's a fair assumption. If we didn't have the basic facts of complaints of the executive controlling the judiciary, then that's when you cannot make any inference.
I mean, I'm curious though. I'm curious. Are you suggesting that
the basic facts?
Are you suggesting that today's outcome is also one that is because of that control?
Oh, Evans, once you accept that the basic facts are true, you cannot exclude today's outcome. So all decisions, why do you think to be careful and that if they keep winning all the cases, national security, it's a national security threat? For the national security minister to tell the judiciary, Evans, I'm not happy to do this, but we are analyzing basic facts. If you had told me that, Martin, it is not true that the Chief Justice said the president should not have a role in the discipline of judges. And number two, Martin, it is not true that the Chief Justice complained that the executive, that the president and his ministers, refused to release money and thereby seek to control the judiciary. Then we couldn't have laid anything on it, because if there's no foundation, you can't lay anything on it. But once these two basic facts are true, then it's a fair comment, which even the Constitution allows.
Those facts may be true, but is it true in all cases that the Supreme Court hears? I guess it's the way I find a challenge with the argument that because, one, there are issues with the independence of the judiciary, and many surveys have shown that, then all cases that come before the Supreme Court somehow have been sort of impacted, tainted by the lack of independence.
Evans, obviously, I'm not one to make such a statement. Evans in the Supreme Court. Oh, Evans, I've done 17 years in the court.
But you're applying it. But you're applying it. I'm asking because you're applying the principle to this outcome, and it may be wrong.
And to every rule, there is an exception. Mm-hmm. To every rule, there's an exception.
And today's outcome may be the exception.
Don't forget. Oh, of course, I can grant you that. It's not a problem. I can.
Oh, goodness. Apologies there. The network just won't help. But let me quickly bring in Frank Davis into the conversation on this. Frank, that is his criticism of what has happened today. You hold a different view. Hello, Mr. Davis. Do you have Mr. Davis on?
Oh, yes, I'm here.
Okay, good. I lost you.
Can you hear me?
I can, yes.
I'm a bit embarrassed and scandalized by what Martin Kpebu is saying. I just cannot believe it. Come on. So Martin, after all your years of working through the Supreme Court, this is the opinion you form? I'm just scandalized and embarrassed. So, Martin Kpebu, because the Chief Justice has said something at her vetting, the Chief Justice's opinion about something, then you make a sweeping statement. Come on. So Martin Kpebu is trying to suggest that in the 2013 election petition, when it was 5-4 against the MPP, let's put it in quotes, and President Mahama was the president at the time, President Mahama influenced the Supreme Court. You see, this path taken by lawyers is so dishonorable And it's so dangerous. And we should not permit these things to just pass. So Martin Kpebu is trying to tell me that in the criminal case just gone by, where the stakes were so high, Atuforsen and Japa, when the stakes were so high, and the matter ended up in the Court of Appeal. Two of the justices of the Court of Appeal acquitted and discharged Japa and Forsen. Martin Kpebu found nothing wrong with it. And Edudi Tamaklo, who is also screaming your seat there, he was lawyer in that case. They found nothing wrong. You see, Evans, when judgments are rendered, I expect lawyers to do a critique, reasoned critique, fundamental critique of the judgment. But when we lace it with political considerations, it becomes bizarre. Now, Martin Kpebu, who doesn't know your political persuasion? I am proud to say I'm MPP. Everybody knows I'm MPP. Who doesn't know your political persuasion? So if you come on TV,
I mean,
with this
what does that go to anything? I mean, does it matter?
No. You see, Evans, don't ask me what does that go to anything. Because now Martin Kpebu is trying to represent that because the MPP is in power and the justices of the Supreme Court have been appointed by the MPP, the executive is controlling the MPP. The executive is controlling the judiciary. So the speaker can say that there's collusion between the judiciary and the executive. And Martin Kpebu wants us to take it as a gospel truth because he sits there and says the speaker sees things that we don't see.
Yeah, it's an opinion of his. You disagree with that. Doesn't mean that he is speaking for a political party.
Please, Evans, I just asked that what political persuasion does he belong to? He should be generous enough to say it.
It doesn't belong to any political party. That must he belong to any political party to have an opinion?
I'm not saying he should.
Okay.
I've just posed questions. I'm not saying he should. Because he seems to be lambasting everything that comes out of the Supreme Court these days. And I'm asking, I've just posed a question, that in the 2013 election petition, when the judgment went in favor of the NDC, for Martin Kpebu's logic, his radiant logic, we should accept that the executive at that time, I mean, they breathed, I mean, they were on the neck of the justice of the Supreme Court to render a judgment in their favor. You see, this is a very dangerous thing when lawyers do. And I will not allow myself to be swayed by these things. I think we should stay focused to the subject, say what we want to say, and leave all these political considerations because it doesn't help. It doesn't help one bit. We have only one country, one Supreme Court, one parliament, one executive. We should not be seen to be doing these things. It doesn't pay one bit. And for a trained lawyer, so will Martin Kpebu go back to the same Supreme Court? Would he go back to the same Supreme Court?
I need to wrap up, but let me give a quick final word on this. I mean, on the back of the admonitions that you put forward. Martin, you accept them in good faith?
Evans, we are analyzing facts. So I'm surprised Frank Davis is gone out to town with all those statements. We are analyzing based on facts. This is logic. You cannot exclude the inferences I'm making. So if you understand logic, I've said nothing new. It's all within the logic of the statement. So I'm surprised he's saying, will I go back to the court? I was there 2 weeks ago. I was in the Supreme Court on the 30th of October. I have a case there, and the next time they invite a better constitutional review. We want to take away the powers of the president to appoint the judges. It's very critical to our democracy. So Frank Davis should stop playing ostrich. We want a better constitution. So let's face the facts. We have to take the bull by the horns. Let's stop playing ostrich. So it's not within Frank Davis to ask me that will I go back to the court. I've been going there. I was there on the 30th. I haven't scandalized the court. We are doing analysis based on publicly available information. I've not come with any personal inferences, right? Once the basic facts are allowed, the Constitution says I can have a fair comment. If you have disputed the basic facts about the Chief Justice complaining about executive role and the discipline and other issues of judges, then Frank would have had an issue. But Mr. Davis cannot dispute that.
Okay.
So please, let's stay within the facts.
Yeah, Martin, thank you very much. And thank you very much to Frank Davis and the lawyer for the NDC, Eduji Tamaklo. Thank you. Enjoy the rest of your evening.